welcome all of you. I'd like to thank the ICN for hosting this event. I'd like also to thank the invitation to moderate this panel, as well to send my greetings to my fellow friends from CADE, Alexandre Barreto, Alexandre Cordeiro, Carolina Helena, also Alessandra, who invited me to be here. Such a pleasure to come back after having worked as a commissioner in CADE's tribunal. And today, I think we are talking about advocacy, to sharing knowledge, experiences, and now today we're talking about interim measures in unilateral conduct. So, but what can we say and how can we define what are interim measures so we can have a good debate and we can have a good point to share different points of view? Maybe we could say that they can be adopted while investigating potential infringements of competition laws. However, I think that my point of view, its main objective is to impose a decision before the investigation ends and before we have all the investigations and all points. But in this sense, I would like here to hear about our panelists, which I would like to thank to being here. We had a good preparation. We discussed a lot of points previously. And I would like to ask you initially, how does it work in your jurisdictions? Does the agencies have the power to impose interim measures? Or if so, is this power limited to specific sectors or practices? And what are the legal criteria to impose them? So please welcome initially Corinne Aaron from the Authority of France. Then we'll have Sidikin Kir from Turkey. We'll have also Mark Schaffer from Switzerland and Carlos Trujillo in this order from Ecuador. It's such a pleasure, and I'd like to give the words to Corinne initially. Thank you very much.
Hello, thank you. You ask if our agency has the power to impose in the interim measures. Yes, regarding France, the French Commercial Code provides the Autorité de la Concurrence, that the Autorité de la Concurrence has the power to take any interim measures that are requested of it or that appear necessary. And for the last 5 years, the authority has issued 3 decisions ordering interim measures and around 20 rejection decisions. I don't know if you want me to go further with.
You can go, yeah, for sure.
J'entends rien.
Verás que capaz que ni lo dejan usar la PPT. Sí, ya ver. ¿Y tú que haces capturas o qué?
Corinne, I think I think there is someone with the microphone open. I would kindly ask to close it. Corinne, you may go ahead, please.
Okay. The power of the power to impose interim measures in France is not limited to specific sectors or practices. However, it's interesting to note that the 3 decisions for interim measures issued by the authority since 2017 concern the digital sector. Interim measures appear to be a particularly well-suited tool as regards competition concerns in digital markets, because in digital markets, a rapid intervention is sometimes the only way to prevent behavior of a dominant player for eliminating competition or fatally damaging commercial partners that are highly dependent on its ecosystem. I can go further if you want with the criteria. Yes. Okay.
Yeah,
Okay, the implementation of interim measures by the authority is subject to strict conditions originating in law and case law. According to the French Commercial Code, the first condition is procedural. A request for interim measures may only be made in conjunction with a complaint on the merits of the case to the Autorité de la Concurrence. With regard to the conditions of implementation, the Commercial Code sets out cumulative criteria. I quote with a free translation our French Commercial Code. Such measures may be taken only if the practice in question causes serious and immediate harm to the general economy, to the sector concerned, to the interest of consumers, or, as the case may be, to the complainant company. The various interests listed by the Commercial Code constitute alternative conditions. It is therefore sufficient that the practice causes serious and immediate harm to only one of these interests and not necessarily to the complainant company, if there is a complainant company. The various, these legal criteria have been supplemented by the case law and doctrine to date of the Cour of Cassation. It's the French Supreme Court. In a ruling of 8 November 2005, the court added additional conditions. The first one is that the reported practice must be likely to constitute an anti-competitive practice. And the second is that the court established a causal link criterion by considering that the reported facts have to be the direct and certain cause of the serious and immediate harm of the interest listed in the Commercial Code. The standard of proof for interim measure is lower than the standard of proof for finding an infringement in the context of proceeding on the merits. As previously stated, the court ruled that the reported practice must be likely to constitute an anti-competitive practice. So the standard of proof for interim measures requires serious evidence to establish that there is a potential infringement. However, the vast majority of rejections for the last 5 years are due to a lack of evidence. In this case, we have a rejection of the complaint on the merits of the case and of the request for interim measures. In some few cases, interim measures have been rejected, but the authority has instructed that the investigations into the merits of the case be pursued. Thank you.
Thank you, Corinne. Such good to know about the legal criteria and especially how does it work about the burden of proof. Thank you very much. Sidgen, could you tell us how does it work in Turkey, please?
Good afternoon, everyone. Thank you for giving me the opportunity to speak on the webinar. Today, I would like to share with you interim measures in Turkish competition law. Turkish Competition Authority have the power to impose interim measures. According to our law, where the occurrence of serious and irreparable damage is likely until the final decision is taken, the board may take interim measures in order to maintain the situation before the infringement. without exceeding the scope of the final decision. This power is not limited to specific sectors or practices, so intervention is made if interim measures is deemed necessarily in the examination of the whole sector. In the course of preliminary investigation or investigation, in order for the competition board to issue an interim injunction, firstly, there must be a suspicion of infringement, and there must be a serious and irreparable danger of harm until the final decision. The standard of proof for the application of interim measures is almost as high as the standard of proof for finding a violation in the context of a trial on the merits. And according to competition board, this suspicions of violation is possible in terms of both existing and future violations. The main criterion for taking a decision is possible harm. The board states that when the possibility of violation arises, the preservation of the pre-infringement situation before it's disrupted will mean the preservation of the current situation. Along with this, the injunction shall be protective of the situation before the breach, and the injunction must not exceed the scope of the final decision. Accordingly, if the board considers that there is a possibility of serious and irreversible damage, it may take interim measures in a manner that protects the situation before the violation can occur, provided that it does not exceed the scope of the final decision. As will be seen, the board's interim measures prevent behaviors that may cause serious and irreparable harms. On the other hand, a request to this effect is not required for the competition board to issue an interim measure decision, and within the framework of the situation and the scope specified in the law, the board may decide on interim measures ex officio. Thank you.
Thank you very much, Silian. Very interesting. I would like also, before going to Mark, I would like to thank all panelists who had a very good meeting. We discussed the format, what topics you should address. So it was very interesting, and I couldn't have done better without you. So thank you very much. Mark, could you please tell us how does it work in Switzerland, please?
Yeah, Luis, thank you very much for the introduction, and thank you very much to be able to speak today. In Switzerland, we have a quite interesting situation because we only have a legal basis which is very general. The legal basis states that the Competition Commission can decide on the appropriate measures, nothing more. And based on this, we pushed the case law, and we tried to push the case law if we can use this for interim measures. And the courts give us the okay that we can use it. And in the meantime, in about 25 cases, COMCO applied interim measures on decisions. However, the case law provided us several guidelines we have to look at and we have to respect in order to take interim measures. The courts stated that in Switzerland, it's only a step to the final decision. The interim measures, these are not a part, but they have to be integrated within an investigation. But it can occur in a quite early stage of the investigation, but must be linked to the investigation. We have to show that there must be a harm that is realized without the interim measures that can not easily be reversed. That means we have to show that if we don't use the interim measures and we wait until the end of the investigation, that certain harm to effective competition can occur that cannot easily be reversed. And then we have the possibility to impose interim measures. And the second thing is that it must be of a certain urgency, that we cannot wait until the end of the decision. And these are more or less the boundaries where we can impose interim measures. Then, of course, we have to look at the proportionality, whether the measures are proportionate or not. But this is more or less on the case by case where we have to look at it. And I think I'll come to that a little bit later. From the proof, it depends on which stage we are in the investigation and, of course, how far-reaching these interim measures are. But prima facie evidence is sufficient. We have to show credible that the harm, the negative outcome occurs within the economy, and that there's negative impact on the effective competition. But we have also another limitation. That means the courts clearly stated that the interim measures must not forestall the final decision. That means the investigation must stay open, and we can't impose interim measures that clearly indicate the result of the investigation itself. It can be, therefore, the limitation is mostly we are securing a current state of the economy, a current status with our interim measures. But it would be quite difficult, and we don't know in how far the courts would follow if we would have interim measures that create a new situation or where we change things. And within this context, it's really based on case law, and yes, it's quite how to say, quite flexible in a way. But on the other hand, it's always a challenge of how to argue, of how to show that these criteria are met. So thank you, Luis, and I'll pass back the microphone to you.
Thank you, Mark. I would like to hear from my colleague, which is very more close than the other ones. Carlos, can you tell us how does it work in Ecuador, please?
Yeah, sure. First of all, thank you to the ICN for this opportunity, and to you, Luis, for the panel. In Ecuador, basically, the Superintendence of Economic Competition does have broad power to impose interim measures. The measures can be imposed in any sector of the economy and regarding any conduct that the agency is investigating. It can be abuse of dominance, restrictive practices, or unfair practices. Basically, the criteria to be met in order to establish an interim measure is to demonstrate two things: periculum in mora and fumus boni juris. I think this is quite common in civil law jurisdictions such as Ecuador. Basically, what we have to prove is that a potential affectation to the competitive process could be done, or to the economic efficiency or general welfare, what is basically what our law protects. It is an urgent measure that can be revised as many times as is required during the investigation. As well, the interim measures can be imposed at any time during the investigation, just before the conclusion of verdict is given by the authority. Okay. Basically, the standard of proofs differs from the one that finding an infringement. If you want, basically the standard of proof to be met in abuse of dominance is to prove that the conduct has the capacity to affect or potentially or real the competitive process, the economic efficiency, or general welfare. But as I said before, with interim measures, that standard is a little lower. You have to prove that is a periculum in mora and also a fumus boni juris, basically that the potential affectation to the competitive process can happen. And in more or less, that's how the interim measures functions in Ecuador. I will pass you now the microphone to you, Luis. Again, thank you.
Thank you very much, Carlos. thank you. It's very good to hear from everybody how you deal and what are the legal criteria. Thank you very much for all of you. But there is something common that I think that's related to all jurisdictions. And what I think is about, we are talking about the timing and the proportionality that the authorities need to have in order to impose the interim measures. I think there is something that we have to deal is about the under enforcement, about not making the decision, or maybe if we do it too strong, and maybe we can make like an over enforcement uh, point, or something that we can do more than we should do it. And I'd like to hear from you, beginning with Corinne again. How do you deal that about making the decision to be proportional, about the timing? Is it should be done in the beginning, in the middle of the investigation? Because if you will wait until the end, of course, you don't need to have an interim measure. You just wait for the final decision. But sometimes the harm is too big. And how do you deal with that? What's the moment? How to make it to be, make it to be proportional? And what are the cares that are necessary for not making over or under enforcement? Corinne, could you tell us how you deal that with these points in France, please?
Thank you. About proportionality, in France, when the condition for implementation are met, the content of the interim measure must satisfy the principles of necessity and proportionality. More precisely, the French Commercial Code provides that interim measures may include the suspension of the practice concerned and the injunction to the parties to return to the status quo ante. They must remain strictly limited to what is necessary to deal with the emergency, pending the decision on the merits. The Cour d'appel de Paris, the Paris Court of Appeal, clarified that the text of the law only cites examples, meaning that the authority is free to take interim measures depending on the circumstances of the case, and which do not suspend the practice concerned or order the parties to return to the previous state. And with this recital, the review court confirmed the authority's power to take any measure necessary to confront the emergency in compliance with the principles of necessity and proportionality. As a consequence, in its decision ordering interim measures, the authority justifies the necessary and proportional nature of the interim measures. It's part of the decision. Thank you.
Thank you, Corinne. Thank you. Thank you very much. Sigden, is it different in your country? How does it work?
The Turkish Competition Authority strikes a balance when applying interim measures. According to Turkish competition law, interim measures are intended only to preserve the status quo before the infringement. In this respect, an interim measures should aim to preserve the status quo before the infringement and should in no way exceed the scope of the final judgment. In this way, the board maintains a balance. If we talk about the parties' right of the defense, it's possible to say that the parties are provided with this opportunity. The measure taken by the competition board decision is considered an administrative act. Interim measure decisions can be the subject of the administrative lawsuits, separate from the final decision. Although it's not clearly stated in Turkish competition law that interim measures can be the subject of the lawsuit, it's stated in the law that judicial remedies are open against broad decisions. And since interim measures may directly and significantly affect the rights of the undertakings, It's accepted that interim measures may be directly subject and annulment proceedings, taking into account of the right of the defense. In other words, although an interim measure is an interim decision, since it may directly and profoundly affect the rights of the undertakings concerned, in order to fully protect their defense rights, it has been accepted to apply the judicial remedy against them, just like a final decision.
Thank you very much, Shigden. Mark, could you help us now?
Yes, in Switzerland, it's quite interesting because the proportionality is part of the process we have to go through to prove. And the courts gave us 3 criteria we have to check under the proportional or under the analysis of proportionality. First of all, the interim measures must be appropriate to achieve the aimed goal. That means it sounds quite obvious, but this is also taken with a second criteria. That means that we can only use interim measures that are strictly necessary to achieve the aimed goal. That means the courts always check whether the interim measures go a little bit too far than what the goal is that we try to reach. And this is something which is on case law quite difficult in Switzerland to achieve, because the company which is affected by the interim measures can always come and say, look, if you would have taken these and these interim measures, it would have a less impact on us, and it would be better for us. And this is quite tricky to argue this. And then, of course, from the proportionality we have from the courts, the interim measures must be reasonable in the sense that for minor infractions, we shouldn't use the instrument of interim measures. They must have a certain extent. The effect or the harmfulness for competition must be in a certain extent in order to be able to apply interim measures. It depends a little bit on the case by case. There are some cases where we decide on interim measures in the beginning of an investigation, quite at the beginning, especially if we have some complaints of other companies in the same sector which are affected by certain behavior of the company. There it might be that we react immediately with the opening of the investigation. On other cases, it's also possible that we are in the middle or even at the end of a case if we think that the company's appeal and the decision cannot enter into force immediately. We can still use interim measures so that the decision is immediately enforceable. Therefore, we look on a case-by-case basis in Switzerland when we apply these interim measures. And of course, the success, as it's only based on case law, is not always evident. Therefore, we use the system quite on a reserved way or very carefully, so that we do not overuse this instrument by the courts, because every time we would lose interim measures in front of the court, this would give another case law which would more or less weaken our possibilities and our marge de manœuvre, how one says, and therefore we are quite reluctant to use it. We use it sometimes, but we are very careful to use it. Thank you.
Very good to hear. Thank you, Mark. And Carlos, how does it work in Ecuador, please? Are you also careful, like in Switzerland?
Thank you, Liz. Regarding to the proportionality in Ecuador, even though it's not stated in our law, as many civil law countries, proportionality is a legal principle of law that we must comply. So always when we are assessing if to impose or not to impose an interim measures, we take into account if the measure is proportionality to the damage that is trying to protect, in this case, the competitive process. Okay, regarding the current situation in Ecuador, I think there's under enforcement. There's not enough interim measures, and I think this correlates directly with the agency resources. As many of the other agencies, I think we do need more resources. The thing is, the same officials that are taking or sustanciando or investigating the principal case has to do the same with the interim measures. So it's like two cases at the same time, and many of the times we do not have like the time or resources to take into account two cases at the same time. So basically the current under enforcement that I think is going on is because the agency needs more resources. Then regarding like the due process and proportionality, basically our measures can start ex officio or with a petition of at any point of the investigations. We have to elaborate and inform in 15 days. So it's basically, yeah, I know it's interim measure and the urgency, but to analyze such amount of information in such a little time and to make an inform can be a little time. Afterwards, we have to do a resolution adopting or discharging the measures in just 10 days. If adopted measures, then the obligate party can ask for the suspension or the modification. But when we are doing our inform and the resolution, the party who is going to suffer the measures cannot say anything. The party who will suffer the measures can point out their point of view once they have been basically notified with the measures. Once they are notified with the measures, they can ask for or modification or suspension, and we have to do another inform now in 30 days, and after the inform the resolution must be basically do it in 20 days. The measures normally ends with investigations. Sometimes they can mutate into corrective measures that it's called also remedies. So an interim measures can basically mutate into a remedy. Basically, in Ecuador, the only thing that the measures cannot do is deprive of liberty. We analyze case by case, and we always look the proportionality. In Ecuador, the most interim measure that has been taking place is regarding abuse of dominance. So basically, the cases are such serious cases that the competitive process can be affected that we think like suspend a contract or something like that could be like proportional to the measure that is asked. So in my opinion, we do take into account the proportionality. Otherwise, the courts will basically stop the interim measure that we do. And that will be it in Ecuador. Thank you, Luis.
Thank you very much, Carlos. We heard about all the jurisdictions, about the how does it work, what are the legal criteria. We heard something about proportionality and all the points here. But I think we are going for the second part of our webinar, and I would like to hear from you. What are the most interesting cases you could share? How was your experience with each one of these? And then after, I think this is the most important thing about the cases that we're going to hear. We're going to have some questions from the audience. So, Corinne, could you tell us how the French authority deal with uh, your cases and how was your experience, please?
Mathieu and I are the case handlers of the last interim measure published last year. And so I will present this case as a specific case. I will present you this interim measure following a complaint from the company Adlux regarding practice implemented by Meta in the online ad verification sector, published last year in May, the 4th May 2023. To explain the case, perhaps first of all, would like to say that the ad verification refers to the processes in the online advertising sector, which are intended to verify the quality of an ad inventory or an ad impression. These services typically include measuring viewability of the ads by internet users, fraud detection, and brand safety and suitability services. The type of services can be offered by integrated advertising platforms for their own ad inventories, as well as by specialized independent operators like AdLooks. In order to cover the inventories of integrated platforms, the independent verifiers need access to their ecosystems. As regarding the access to Meta's ecosystem, Meta has created 2 partnerships. One for viewability in 2015 and a second one for brand suitability and brand safety in 2019. From 2016 until 2022, AdLooks requested to have access to Meta, similarly to some of its competitors. However, Meta never granted this access to AdLooks. In its decision for interim measures, the authority considers that Meta's practices are likely to constitute an abuse of a dominant position. Firstly, because Meta has not defined transparent, objective, non-discriminatory and proportionate criteria for accessing and maintaining viewability and brand safety partnerships. And secondly, the refusal to grant AdLooks access to the partnerships is likely to be qualified as discriminatory, as AdLooks is in a situation comparable to that of certain operators who were able to access these partnerships with regard to the conditions applied by Meta. Furthermore, the exchanges between Meta and AdLooks reveal that Meta never intended to integrate AdLooks. In this case, the authority considers that Meta's practices cause serious and immediate harm to the independent ad verification sector and to the interest of AdLooks. In our point of view, the biggest challenge in this case was to verify the immediate harm criteria, as the first refusals of access dated back to 2016. Meta argued that the condition of immediacy of the harm has not been established, given the long-standing nature of the practices in question. However, several factors were considered by the authority to establish the immediacy. First of all, the fact that AdLooks sent Meta a new request for access in August 2022, followed by a formal notice to which there was no real response from Meta. And second, the risk of AdLooks exit from the market before a decision on the merits. Thirdly, during the investigation, Meta stated that it had redefined the criteria for the viewability and brand safety partnerships on January 2023. And these new criteria are likely to affect all players operating in the independent ad verification sector, and at least the entry into force of the DMA. Meta's practices are likely to artificially reinforce the barriers to entry in the sector, in a sector that is already largely concentrated, which justify urgent intervention by the authority. At a time when the European legislator wanted to encourage the development of this sector to remedy the issues relating to a lack of transparency. Thank you.
Thank you very much, Corinne. Signen, could you tell us, please, what are the specific cases and how did you deal with interim measures in Turkey?
There have been a number of decisions where the Turkish Competition Board has addressed conduct that could cause serious and irreparable harm. I would like to talk about a decision for 2022. The board was investigating an online betting company called Nesine. This company was a dominant company in the online betting games market. The subject of the investigation was the exclusivity agreement signed by this online betting company. This company, which was a party of the investigation, was excluding its competitors by adding exclusivity clauses to the advertising agreements it made with various companies. One of the agreements was made with the online live score tracking platform called Matchkolik. The online betting company examined within the scope of this agreement was working along with the online score tracking platform, which is very important for betting players, and prevented its competitors from entering into an advertising relationship with this platform. Due to this exclusivity provision, the competition concerns arose as rival online betting companies could not be listed on Matchkolik or place any advertisement in Matchkolik's inventory. If the final decision of investigation was awaited, another sports season in which betting could be played would pass and competitors would suffer losses. Therefore, the Turkish Competition Board, took interim measures to remove the exclusivity provisions, taking into account the risk of serious and irreparable damage until the final decision. With this decision, the Turkish Competition Authority issued an interim measures because of the concern about the potential for serious and irreparable damage to competition and the market, in addition to the risk of the market closure. Nesine interim measure decision has importance as it demonstrates the board approach, which is a signal that the board is following the recent developments in the sector very closely. Decision also indicates that the board will not hesitate to impose interim measures where necessary with a view to maintain the effective competition in the market. Thank you.
Thank you very much. I think that we heard a lot about digital markets, and I think the interim measures are very used and apply in this sector of the economy. And I think when we are always discussing about that, Mark, in Switzerland, is it different? And what are your experiences? Thank you very much.
Luis, thank you very much. Yes, until now we didn't use interim measures in digital markets. I want to show you the last case where we used interim measures. It was in the telecommunications sector. We have a certain specific situation in Switzerland that we had new companies that entered the market to construct fiber optic networks. These were more or less the power suppliers which started to construct fiber optic networks in Switzerland. The incumbent telecom operator then entered into agreements with them so that they could construct the fiber optic networks together. And thus, industry standard developed in Switzerland, which is based on the point-to-point network architecture. A point-to-point network architecture means that from the central office to each household, there is a distinct, separate fiber optic line, so that third parties can unbundle this line and they can use it to offer their own services. That means they can lease one of those fibers and then provide their internet services to the customers directly from the main office of our incumbent telecom company. Then the telecom company in those regions where they constructed the fiber optic network alone, where they didn't have a cooperation partner, started to change the architecture in which they constructed the network. They didn't construct it in a point-to-point network, but in a point-to-multipoint network. That means there would be several households which would be regrouped to one fiber optic line, and with the effect that third parties could not lease single lines anymore. So they would have to resell the services of the incumbent and couldn't provide their own services via the network. And this posed a major problem in Switzerland, because a lot of telecom companies had built their business model on being able to access the network and to provide their own services and not just to resell the services of the incumbent. Based on this, we decided to intervene and to forbid the incumbent company to construct their fiber optic network in this manner that third parties cannot use it. And this was quite difficult to argue, because on the one hand, they had good reasons, because building the fiber optic network in a point-to-multipoint version is much cheaper for the incumbent, of course. And on the other hand, yes, we had also to be very careful not to go too far with our interim measures, that the incumbent could tell, well, we could construct in another way so that we can achieve the same goal. And it was quite difficult to find a way in between. But we clearly focused on the goal that they have to construct in a certain way that a layer 1 access, or that the access to the physical network, is possible. And we left open how they would realize it, or how they would construct in the end. So we didn't go into the details. We just gave them the goal to achieve with our interim measures. And it went in front of the courts. We went till the Supreme Court of Switzerland, and the Supreme Court confirmed our interim measures on this case. And we are now nearly finished with the final decision. In this case, it will be issued during this year, and we will see how it goes on with this case. So thank you very much, and I'll give you back the microphone, Luis.
And I give it back to Carlos. Please, Carlos, tell us about your specific case.
Thank you, Luis. I want to talk about the case. It was very interesting. It happened a couple of years ago. It was about ATM networks. Basically, in Ecuador, there are only 2 ATM networks. One is called Banred. It's owned by the biggest banks in Ecuador. And the other one is called RTC. It's owned by financial institutions that are called cooperativas. The cooperativas basically serve the people who are in the rural areas. Basically, these two ATMs networks had an interconnection, and all the people around Ecuador can take out their money through the ATMs, no matter what, if they were members of a bank or a cooperativa. Banred and RTC had an agreement, had a contract that was about to expire. Previously, like 6 months before this contract expired, Banred says to RTC, if you want to continue the interconnection between our networks, you have to pay among 600 to 800 more than what you've been paying the last 5 years, basically. So RTC put a complaint in the agency. We look through the file, and basically we have to maintain the interconnection between these ATM networks, at least during the investigation. This was a huge case, and it was very complicated because it was the first case that Ecuador at least has a multi-sided market case which was investigated. We as an agency have to do more than form informs. We at the moment do not have enough expertise in related banking markets, especially in ATM networks and interconnections. The interesting thing of this case, it was that we have to do like 4 informs because we accept the interim measure and the banks ask for it stops. We do another inform as well, and the banks once again ask to stop. As you may know, basically the dominant undertakings has almost unlimited resources and a lot of lawyers who basically knows the law very well. So it was very, very demanding for the agency. Nevertheless, we maintained the interim measures. And once when the case was over, the good thing, and it was very, very interesting, is that even there was no more interim measures, and basically we do not take as a remedy to maintain the interconnections, the parts reached to an agreement. And nowadays they continue their interconnections without a measure or a remedy. So we think it's a very successful case because all people in Ecuador, it doesn't matter if you're in the city or the rural areas, you can take out your money through an ATM. Thank you to this case. Basically, that was like the most interesting case we have had in the period of the last 3 years, and that's where our main concerns and difficulties and how we deal with it. So thank you, Luis.
Thank you, Carlos. Do we have any questions from the audience? I'm not so sure if I can read the chat, but if someone reads, can tell me here, help me. Anyway, I think that we could go for the final remarks. And if you could help me with something, and how do you think that international cooperation can help you in improving your system, your experience, and how do you see is going to be the future for interim measures? Corinne, could you go for your final remarks, please?
I think it's very interesting what we hear is to share this experience is always good for a case under. Thank you very much for the contribution of everybody.
Thank you, Corinne. Signan, how do you see this panel, and how do you think this experience can contribute for your working for your issues in Turkey?
I think it was a meeting where very useful information is provided. Thank you very much to everyone to their efforts. Thank you.
Mark?
Yes, for us, it's also very interesting because our possibilities to impose interim measures are based purely on case law. So it's quite interesting also to see what are the criteria in other jurisdictions, what they have to take into account. This can help us in future for our case law, of course, to apply certain criteria to have a look on how we present the case to the courts, and this might help us to push our boundaries a little further. And this may be also interesting for other jurisdictions who don't who have maybe quite open quite open legal basis to impose interim measures, to have a look what are the criteria and how different other or competition authorities tackle those problems they have with these criteria in order to push the limit a little bit further. And in this context, I thought it was really interesting to hear from all of you, and also to hear from other cases within the ICN network or anywhere else, in order that we can all further enhance our case law in Switzerland. So therefore, thank you very much, and it was really a pleasure to talk to you.
Thank you very much, Mark. Carlos, and how about you?
Thank you, Liz. I think this is a huge opportunity for all of us. Basically, regarding Ecuador, our agency has no more than 12 years, and the people who are reaching the cases and taking out or stepping out the cases, we've been working here 5 to 7 years, so everything is very new for us. And with these kind of opportunities where we can share the experience with agencies that have more time and resources and expertise in the subject is always good. For instance, it's very, very interesting what Mark told us in Switzerland, that is basically all through case law. Here in Ecuador, we have civil law, we have the codes, but it's always very, very interesting to hear about the case of Meta, and to hear about the case of the gambling in Turkey. Is always very, very enriching, and I do appreciate these kind of opportunities. So thank you.
Thank you, Carlos. It was very good for me to be with you on the last days. We had several discussions. I had brought, I think, 12 topics, and you told me, no, we maybe 2 or 3 would be more than enough for 1 hour webinar. So it was very nice to make this arrange and to learn with you. And thank you very much, because the time I didn't have to be a timekeeper today. You were all accomplished with your timing and with your thoughts. So I think these initiatives from ICN and from our antitrust agents, they are very good, because they can show us different points of views, different perspectives, different experiences. So I think that we live and we went today with a very rich experience, and we will definitely guide and manage our cases and our suit cases for the future. So congratulations for STN. Thank you for the opportunity for being with you too. And thank you especially for the panelists for such rich content and such good experiences. So I'd like, in behalf of Kaji, to thank all of you. And I don't know now if I should say good evening or good morning again, but thank you very much for this wonderful experience. Thank you very much.